Our President, Tracy Alexander, will shortly introduce our special guest speaker, Leslie Millin. We will select the most popular questions being posted into our Q&A to put to our speaker later on after she's spoken, and this will follow the presentation. So please do join in the Q&A, post your questions or like a question. Please be aware that we will be recording this event to upload to our website for those who could not attend this evening. I'm pleased to now hand over to our President, Tracy Alexander.
Thank you very much indeed, Leslie, and thank you to so many of you for joining us this evening. This is clearly the way to go, I think, in terms of trying to keep our events going. So I'm sorry we haven't been able to put on any of our events recently, but under the current circumstances, we've got a fantastic turnout tonight, and we're really, really lucky to have with us Leslie Millin, who's a recent addition to our executive council. Leslie is a barrister. She specialises in many aspects of law, and she undertakes work for several pro bono clients, which is entirely in keeping with our BAFS principles. For those of you who are joining us for the first time, BAFS was set up in 1960 in order to look into miscarriages of justice, and by combining the three disciplines that we promote, medicine, science and the law, to see how we could all work together in order to improve the conditions in the criminal justice service. So as Leslie Knott has said, there'll be a chance for questions at the end, and we'll also be putting up our membership slide in order to encourage some of you to join us who might not be members yet. So please do have a look at our website at the end. I'll be speaking to you towards the end for the question session, but for the moment, Leslie Millin is going to introduce herself and begin her talk. So thank you very much indeed, Leslie.
Thank you. Good evening, everyone. I am a barrister and I specialise in inquests, personal injury and employment law. And I've been asked to present this webinar this evening, which I'm absolutely delighted to do. And what I am wanting to do tonight is I usually represent organisations such as NHS Trust, Metropolitan Police or local authorities and this kind of thing. And I'm always being asked, particularly when I represent NHS Trust, by doctors about what to do, because quite frankly, a lot of them haven't ever been to an inquest and they have absolutely no idea of what to do and what the procedure is. And it's always helpful once we start to go through what is actually required. And so this is what I was going to do this evening, rather than discuss lots of legal points with you, because I think it will probably be more helpful for me to talk about the inquest itself, purpose and scope, etc. I was involved in one of the first inquests, which went to an Article 2, and I was led by Philip Havers QC in the higher courts, and that was an inquest which started in Luton, and the person who was representing the person who had died in the family wanted to blame the NHS Trust that I was representing and wanted to broaden the scope of the inquest. I'll be talking about this later on, but it's called an Article 2 inquest, and he was trying to extend this just for doctors and consultants, and it didn't actually work, and we got to the Court of Appeal, and then the family withdrew for various reasons. But it's an interesting case, and now we have quite a lot of Article 2 inquests, so I will be talking about that tonight. But what I wanted to start with was the purpose and scope of a coroner's inquest. And sometimes I'm asked by doctors, again particularly because obviously they're looking after the patients, when do they report a death, and when do they not have to report a death? And I always say to them, well, not all deaths are reported to a coroner, but the coroner must be informed that the body of a person is within their area, because all coroners have separate areas, when there's reason to suspect, and there are various reasons to suspect. One of them is that the deceased died an unnatural death. And another is the fact that the cause of death is unknown, or the deceased was in custody, and in custody means in prison or in police custody or in an immigration detention centre. And there is a distinction to be drawn between a death which must be reported to the coroner and the process when the coroner is actually opening an investigation into the death under Section 1 of the Coroner and Justice Act 2009, because that actually means that he's decided to open an inquest, whereas when you report a death, that's different. So under the Notification of Deaths Regulations 2009, and I will keep 2019, sorry, S1 2019 1112, this sets out the circumstances in which a registered medical practitioner is under a duty to report a death to the coroner. And the obligation to report arises if the death is suspected, and this is for medical practitioners, to be unnatural. And the Chief Coroner's Guidance, number 37, informs the coroner that the vast majority of deaths from COVID-19 are due to the natural progression of a naturally occurring disease, and so will not be referred to the coroner. And that's a question I've been asked on several occasions recently as to whether they should be reported or not. So that is the guidance. Death must be referred to the senior coroner if the registered medical practitioner suspects that the death was due to poisoning or exposure to a toxic substance. And when I'm talking about a senior coroner, that is the new term, well, new since 2009, that is used now for actually HM coroner before 2009. But now we call him the senior coroner. So it's exposure to a toxic substance, the use of a medical product, controlled drug or psychoactive substance, violence, trauma or injury, self-harm, neglect, and that would include self-neglect, patient undergoing medical treatment, industrial disease, and in any circumstances when the medical practitioner feels that the death was unnatural. And the rules for certification of the cause of death were relaxed during the lockdown on COVID-19. It is a little bit uncertain at the moment whether they are still relaxed or not, but at the time when there was lockdown, this allowed for any doctor to complete the medical certificate of the cause of death and not the actual attending doctor. And that's under the Coronavirus Act 2020, Section 18, Schedule 13. And the Office for National Statistics produces guidance for doctors on their obligation to notify coroners, which is available online, and it is quite useful to look at that if you need some guidance. But basically and overall, anyone may report a death to the coroner. So if I then move on to terminology, the Coroners and Justice Act 2009 introduced some new terms, which I've just referred to, and it has made quite a difference to various terms that are used. As I've stated, senior coroner was HM coroner. The area coroner was the deputy coroner. And then there's an assistant coroner now. And conclusions, findings and determinations are now actually the old verdict. So that's what the coroner will never now refer to a verdict. He will always refer to determinations and findings and conclusions. So the purpose of an inquest is to, and if you attend an inquest, you'll always find that the coroner will say this, is to ascertain who the deceased was, when the deceased came by his death, where the deceased came by his death and how the deceased came by his death. So it's who, when, where and how basically, and that hasn't changed, it's always the same. And the coroner or jury cannot express any opinion on any other matter other than these 4 questions. And it's very, very important that they stick to these four matters. There also mustn't be any determination on any issues of civil liability or criminal liability. So when the coroner does his determination, he can't actually make any kind of determination on that. And moving on to the scope of the inquest, it is actually for the coroner to decide on the scope of the inquest. In fact, everything is really down to the coroner. In the leading case, on cases which do not engage Article 2 of the European Convention on Human Rights, these cases are known as Jameson cases, and that is the leading case on non-Article 2 cases. And in that case, which you'll find that the coroner often refers to, Sir Thomas Bingham, who was then the Master of Rolls, provided guidance on the coroner's duty in relation to the scope of an inquest. And he said it's the duty of the coroner to ensure that the relevant circumstances are fully, fairly and fearlessly investigated, and the responsibility is his, and he must set the bounds of the inquiry. So, as I said, it is always down to the coroner to decide how the inquest is going to be run. And these types of inquests, as I said, are often referred to as Jameson inquests or non-Article 2 inquests. And the extended scope inquests are actually Article 2 inquests, or they can be referred to as Middleton inquests. And Article 2 of ECHR was incorporated into English law by the Human Rights Act 1998. And it imposes on the state a positive duty to protect life and a negative duty not to take life unlawfully, and procedural duty. And this last duty is most encountered in coroners' courts. And if a person dies in the custody of the state, for example in prison, the system by which the procedural duty is discharged is the coroner's inquest. So basically that's saying that if somebody dies in prison, then the case will fall under Article 2, and it will go to the coroner's inquest, and I'll come into later on what the coroner actually has to do at an Article 2 inquest. But in the leading case in Article 2 inquest is called on the application of Middleton and West Somerset Coroner, the House of Lords set out the type of inquiry that's required for this extended inquest. And this is that the coroner must initiate an investigation, can't just leave it. It's not the responsibility of the deceased's family to initiate it, and it must commence promptly, and it must be conducted by an independent person, and that independent person would be the coroner. And it must involve the deceased's family and provide them with access to relevant documents. And it must be open to the public, and it must be effective and ensure the accountability of the state agents, that is, for example, prison authorities. And the duty to investigate under Article 2 arises where there has been any arguable breach of one of the substantive duties to protect life under Article 2. And where the state had assumed responsibility for the individual's welfare or safety, such as prison, say a psychiatric hospital, or immigration centre as well, then the operational duty under Article 2 is likely to be engaged. And in such cases, the coroner will decide how much control the state has over an individual. And detention in prison, psychiatric hospital, etc., the degree of control will be considered high. And so if somebody dies in a place such as prison, it will almost invariably be an Article 2 inquest. And no operational duty will be deemed to apply to a person receiving ordinary clinical care. So this is what I was actually referring to with my inquest in Luton and Article 2, because the person, my opponent, was trying to get the principles which I've just used for prisons and immigration centres to be used for doctors in hospitals. Which would make this absolutely untenable to have doctors having this high standard and extended inquest every time a patient dies in hospital. And the leading case for this is Rabone, that's R-A-B-O-N-E, and Pennine Care NHS Trust. And it's in the inquest reports 2012 UK SC2 at 22, and it's also in the All England reports 2012 2 All England at 381. There's also a more recent case, R on application of Maguire and HM Senior Coroner for Blackpool, and that's the reference to that is 2020 EWCA Civil 3738 at 74. So whether there's an Article 2 obligation to hold an inquest into the death of vulnerable adults, vulnerability would not of itself trigger the duty under Article 2, and this was held in Maguire, but it does depend on the circumstances. So if a vulnerable adult was perhaps in a place where there was a degree of control which was high, then an Article 2 inquest would more than likely be held. But if it was just a vulnerable adult, then it probably wouldn't. But I'll come on to that because the coroner does have to make a decision on whether an Article 2 inquest is going to go ahead or not. So in cases involving medical deaths, a broader Article 2 inquest, as I've said, would only be required where there had been a systemic failure. And it's not in cases where issues were in fact individual negligence by medical staff. And but that was the Goodson case that I was involved in with the Bedfordshire and Luton Coroner. And coroners must make a decision on whether to hold an Article 2 inquest. And this decision must be made before the inquest is held. And this will be based on the information that they have and representations from the interested parties. And you'll often find that there's quite a lot of conflict with possibly families saying that there should be an Article 2 inquest if it's a hospital death, and the hospital saying, no, there shouldn't be, it's just a normal negligence case. And so to decide on that, there would be a pre-inquest review where both sides would make representations to the coroner, and then the coroner would have to make up his mind or her mind on whether to hold an Article 2 inquest. But the coroner can actually change his or her mind during the inquest, depending on the evidence. So if it started out as an ordinary inquest, the coroner could adjourn and say that he wanted to make it an Article 2 inquest and go from there. It just simply depends, but that's fairly unusual. Usually a decision is made at a preliminary hearing. And where the Article 2 is engaged, the how question, that is the questions that I was talking about originally, how, where, what, when, why, the how question is expanded, and that's to ascertain in what circumstances the deceased came by his or her death, as well as the means by which this occurred. So that's the Article 2. Some people do find it quite complicated, but once it's been to a preliminary hearing, everything becomes a bit clearer. So And sometimes Article 2 inquests can take 6 to 8 weeks, even if it's just an ordinary Article 2 inquest and not something like the Grenfell inquiry. It just purely depends on the circumstances. So if you're called to an inquest by the coroner, the coroner must open the inquest as soon as reasonably practicable after the duty to investigate is engaged. This has become a bit difficult lately because of COVID, but I think everybody's doing their best, and now I'm attending coroner's inquests online, as I am with other court hearings, and they've all been absolutely fine. So I don't know if this is the new normal, but we'll have to see. So with preparation for an inquest, first of all, there would be the pre-inquest review, and it's called a PIR. So if you see that referred to in coroner's correspondence, that's what it means. And the other thing that coroners often use, which absolutely baffle people who've been called to an inquest, is IP. And IP is interested party. So with a PIR, that's pre-inquest review, this should be held in more complex investigations where there's a need to discuss issues which can't be dealt with by email. Sometimes the coroner does try to, even if it's not an Article 2 inquest, to engage by sending emails, but if it really does get complicated, then it's better to have at least the representatives and the family there at a PIR to discuss the issues. And the issues that are discussed in PIRs would be who is an interested person, that's an IP, and the scope of the inquest, and whether Article 2 is engaged, and whether a jury is to be summoned. There's often a lot of argument when you're summoned to not really witnesses, but if a PIR is held, it often takes quite a long time because there's an amount of legal argument on whether Article 2 is engaged and all the authorities have gone through, and whether a jury is to be summoned. So those are two things that really take up some time. There's also disclosure to IPs, to interested parties, and I will come on to that later, but this is the disclosure of documents that you need to actually have the inquest progress. Once you're called to an inquest, you'll need to have, for example, a post-mortem. And witnesses are discussed at the PIR, which means the coroner is trying to work out how many witnesses he should call and who's relevant. And also another interesting aspect of coroner's inquests is expert evidence, because sometimes you do need to, I mean not very often, but if it's a really complicated medical case, you might need expert evidence, or even not a medical case. Sometimes with families, if it's a road traffic accident, they may want some expert evidence from people who deal with traffic collisions to assist them at the inquest. But you can't just go off and get expert evidence and demand to use it at the inquest. And you should also bear in mind that expert evidence is often quite costly to obtain. So it's always a good idea, if you're involved in an inquest where expert evidence may be required, that you actually write to the coroner, or get your solicitors to write to the coroner first to ask whether you may call an expert. And if the coroner says yes, that's fine, sometimes he contacts the other side, or well, the other side in an inquest, but family or organisation. So if it was the organisation that wanted an expert, the coroner may contact the family's solicitors and say, say the NHS Trust wants an expert. Is that all right with the family? Sometimes it isn't all right with the family, and there's arguments on whether an expert should be called. So it's always best to engage with the coroner on that particular aspect before you go off instructing experts. And also discussed is the content of a jury bundle, because there's often, with an inquest, if it's a large inquest, there's often an awful lot of documents, and you can't just put everything in front of a jury. You have to decide between you and the coroner, what should go in the bundle. And it's things like the post-mortem statements, things like that. It just really depends on what the coroner thinks. And you would also discuss at a preliminary hearing the timing and location of the inquest, and any special arrangements such as CCTV, video links, site visits, etc. Site visits are really interesting, actually. I did one inquest where we had a site visit to a police station, and I'd never been in the cells before because I don't do criminal law, so we were actually taken into the cells and shown around, and it was really incredibly interesting to see what it was like. And one thing I always remember about going there was the fact that all the I suppose you call them prisoners, actually have to put their shoes outside the cell, because I understand it's in case they try to take their own life or something. So there are lots and lots of pairs of trainers outside, and lots of noise coming from a cell. But it was incredibly interesting, and I was really lucky to be able to go and have a look around. So anyway, disclosure of information to by the coroner to interested parties. The coroner controls disclosure. The coroner just controls everything, and he is the person who runs the inquest, and he is the person, there's nobody else. His officer does what the coroner wants, but the coroner just considers everything and decides what to do. So he controls disclosure, and there are two stages to disclosure. There's disclosure of material to the coroner. So if the coroner's summoned you to an inquest, he might ask you to provide some documents. Or if the coroner just notifies you that you might be summoned to an inquest, he may ask you for documents. And then the coroner delivers these documents an onward disclosure to the other parties, so that you all have the same documents. And documents should include the post-mortem, any other investigatory reports, such as, for instance, the fire brigade, or if that was the case, or if someone else had done an investigatory report, disclosed it to the coroner, and any other relevant documents that the coroner considers are relevant that should be disclosed to the other side, to the family or to the organisation. And with witnesses, the coroner again decides on which witnesses to call, and the IPs, that's the interested parties, should be provided with a witness list in advance of the hearing. And if you're called to an inquest, it's really important, if you're represented by a solicitor and counsel, they'll probably do it for you. But if you're not represented, you should always ask the coroner or the coroner's officer for a list of witnesses, because that is absolutely key to the whole inquest, to find out who's being called. And the witness list will actually indicate whether the coroner intends to actually call the witness or read the evidence. And it's incredibly helpful to have that before the inquest, so that you know a lot more whether a witness is going to attend and actually give live evidence and will need cross-examination. Doesn't occur at an inquest because it's not adversarial. It is just a court of record where people question. Sometimes I wonder when I'm in inquest whether that's right, and people do appear to be cross-examining, but it shouldn't happen, and it should be a very civil procedure where you ask questions to try and ascertain as much as you possibly can. And there is nothing to stop a witness, as I've said before, obtaining their own expert witness. So that's certainly something that you can do. And the coroner has a duty to make reports to a person. This is actually after the inquest, when the inquest is finished and the coroner has made his, what used to be a verdict, but now's a conclusion. He does actually have a duty to make reports to a person or an organisation or local authority or government department where the coroner feels that further action should be taken to prevent future deaths. So again, if it's called a PFD, and it's not something that anybody particularly wants at the end of an inquest, because for example, if it's an NHS trust, it would be a letter to the chief executive, and the coroner also sends one to sort of higher government bodies, so it's all on record. And that's when the coroner usually calls somebody at the inquest to sort of give a view on what you could do to prevent future deaths and what steps have actually been taken by the organisation to try and prevent future deaths. So it's something possibly to be avoided if at all possible. And then with findings and determinations and conclusions, it's just terminology again at the inquest, but findings are the particulars which are recorded on the record of inquest, which the coroner completes, and determinations are matters decided at the hearing, such as the cause of death, and conclusions are what used to be the verdict. And the verdict could be accidental death or misadventure, alcohol or drug-related death, industrial disease, lawful or unlawful killing, natural causes, could be an open verdict, road traffic collision, stillbirth, suicide. There's also neglect, but neglect is not a freestanding verdict, and it should usually come with something else. So it could be natural causes caused by neglect, and neglect is a gross failure. The very last type of old verdict or conclusion you could have is a narrative conclusion, and that's where the coroner just gives a paragraph or a sentence on what actually happened. So it's just a narrative, and that often takes quite some time to agree with the family or the organisation, because it's sometimes felt the coroner's put too much or too little in. And personally, I prefer just a normal verdict of natural causes or accidental death or something like that, because it's just very clear to the family on what has happened. But that is the inquest procedure in a nutshell. I do hope I haven't been too legalistic, but I do hope that you found it helpful.
I like that a lot, Leslie. Thank you ever so much. Unfortunately, it started to make me think that for all the inquests that I've been to so far, I was kind of just winging it. I wish you and I had met years ago. I could have asked you about, I've been asked to give expert evidence at an inquest, and talk me through it. We should have done this before. So before we hand over to the floor and see what questions we've got, I was just going to ask you a couple of things because I'm allowed. The narrative verdict, I've never really understood what happens after that. So you see the result come out and you'll say there's a narrative verdict.
Yes.
And you've just said, so that could take some time to agree with the family. What if the family doesn't agree? Well, I mean, obviously, presumably the coroner's got ultimately a decision to make, or what happens then?
Yeah, it does take, I mean, on one occasion it took a morning to decide between us. It was my opponent, another barrister and myself, and the coroner, and obviously the people behind, the family and the organisation I was representing, who were both saying things on each side. and it's very difficult because both won't budge, they won't move an inch. So the coroner has to come in, and then he will take, because it's normally written down, the coroner normally presents it to you as a typed sort of document, and then he says, look at that between you and see if you agree. And if you don't agree, he will then take it away and try and make some sort of changes to it that are acceptable to both sides. And then if it still isn't agreed, then the coroner will just say, well, this is what I'm putting, and that's it really.
Yeah. It's quite good that the coroners have so much authority under those circumstances, isn't it? Because then at least they can forge ahead. So you said earlier also that it's the coroner's decision whether there's going to be a jury or not, but there is still discussion between potentially you and your counterpart about whether or not a jury should be called.
I mean, quite honestly with that, it is overall the coroner's decision. If it's a PIR, if it's a preliminary hearing, we are, when I say we, I mean myself and other counsel are allowed to make representations on whether there should be a jury, and there's just the usual arguments on whether there should be or not. But I think at the end of the day, without being cynical, I think the coroner has actually probably already made a decision because, you know, obviously they have so many inquests before them, they're so experienced. They probably looked at the papers and decided that this does require a jury, but they do hear us both, or 6 of us sometimes, on you know, what it should be. And I mean, obviously they take all our arguments into consideration and then make a decision using that information. But obviously with a jury, it takes longer to finish an inquest because there's a lot more, the coroner has to address the jury, and there's a lot more considerations to take into consideration. Sometimes a jury member might go sick or something like that. There's so many things that can happen, whereas if there is no jury, then it is more, I'm not saying it's easier, but it's more straightforward, I suppose.
So, okay, final one from me, and then I'll hand over to the floor because obviously there are others eager to ask. But if it were you, then what would it be about a case that would make you want to argue to have a jury to hear the evidence? If it was a collision investigation or something or other, do you think that potentially they've got a more emotive response to the events? What would colour that decision?
Yeah, I think you've hit the nail on the head there. Actually, if it was a road traffic, I think that a jury could be. I mean, not just a bump. I mean, where somebody's unfortunately died, but if it was as I saw the other day, 2 buses crashing and cars crashing into that, you know, sort of a major incident, then I think that a jury is very helpful because they've got that kind of objective view, and some jury members are extremely helpful. They will actually, you can see them, they sit there, some aren't, but a lot of them get very, very involved in it, and they sit there taking notes, and they ask some very good questions as well. So in something like a road traffic, which is something that everybody is familiar with, I think it's good. I think they struggle sometimes with NHS inquests when there's sort of complicated, if you have medical experts for both the family and the trust, for instance, and then there's a jury there as well. They do tend to struggle a bit with the terminology, and sometimes they you know, I mean, why should they? They're not medical experts, but it's just very, very difficult to try and marry in the medical knowledge with the work that they're supposed to be doing.
Thank you. Just to throw in there, I'm not touting for business, but we have an excellent collision investigation unit here in the city. I'm sure if you were looking for a cont review, they're highly trained, highly skilled. We don't get that many car crashes, so, you know, I'm trying to farm them out a little bit for the future. So I'm going to hand you over to Leslie Knott, who's been collating the questions, but I shall still be here. I'm just going to leave you and Leslie to sort out the questions from the audience, and then I'll come back in a few minutes.
Thank you, Tracy. We have a question that I'll read out first, and that is, coroners today don't have to have joint qualifications, medical and legal, only the latter. In your experience, does that mean that the coroner himself or herself may have to seek additional expertise to help in his or her determination? And if so, how is that person appointed or chosen? Does the coroner simply rely on experts appointed by either side?
Well, coroners always seem to be very wise people, you know. I mean, as you've correctly said, before, I think it was 2009, they could be dual qualified, and they often were, but sometimes they weren't. So there were still coroners who were just lawyers or just doctors, but now they can only be lawyers, and I've just found that there hasn't really been a problem, because they're just dealing with inquests day after day, and I think that they do become quite sort of expert in dealing with things. And yes, if there's medical difficulties, then the coroner will call their own expert. It's not just for the organisation or the family to instruct an expert. I mean, the coroner doesn't have to ask anybody. He can just say, I've instructed whoever to as expert evidence, and they do. But I was at an inquest in February, and it was really interesting, because it was a difficult C-section, and unfortunately the baby died, and the coroner was really excellent. It went on for several days, but the coroner was absolutely excellent. But he got a lot of information from the pathologist, and she was very helpful as well, and he recalled her about 3 times, and I asked her a few questions and something else came out. And I think that's how coroners do sometimes proceed. You know, they will ask the pathologist various questions. I mean, obviously the pathologist is dealing with a dead person rather than a live person, but they're still doctors, and they're still very helpful.
Thank you for that, Leslie. I have another question from Michael Lane. He says, would an Article 2 inquest be triggered by the death of a voluntary patient not detained under the Mental Health Act in a psychiatric hospital?
If it's in a psychiatric hospital, oh, did you say not detained?
Yes, so not detained under the Mental Health Act.
There's always this argument, isn't there? If it's a voluntary patient, I've never been able to understand this, quite frankly, because they go in as a voluntary patient, but you can't go out. Do you see what I mean? Once you volunteered to put yourself into the hospital, then you have to be allowed out. You can't just say I'm going out. So in that case, they are, I'm not saying they're detained, but they are, because they're not free. So I would say that an Article 2 inquest, I mean, it's very interesting actually, because it may be the topic of a PIR. I mean, you may go and have these arguments to say, well, actually, exactly what I've just said, you know, a voluntary patient isn't a voluntary patient because they're not free, and they have to seek approval for various things that they do. So, but it depends, I think, again, on the circumstances as well. I mean, the coroner's got some leeway, but if he gets it wrong to decide on an Article 2 inquest, then he's going to be dragged off to the administrative court to see whether that can be reviewed.
Thank you for that. Thank you. I think if anyone else has got questions, they're welcome to direct them to us at our email address at BAFS, and we can forward them to Leslie. In the meantime, I'll hand back to you, Tracy.
Great, thank you. Thank you very much, Leslie. So I'm just quickly going to say some thank yous to Leslie Knott, who you just heard from, and also Alvaro, who's been keeping us in check and organised all the technical stuff that I would have been completely incapable of. But obviously, mostly thanks to all of you for joining us. Essentially though, Leslie, it was great, and I wish we'd have asked you before when we could all get together in person, but I kind of think this format really fitted your subject matter and your expertise. So I'm really grateful to you for giving up your time today, and super glad you've joined us on the Executive Council.
Thank you.
And I hope you'll stay with us for some time to come. When we're all allowed out again, we'll do this in a different footing with some wine and cheese afterwards. So thank you all again to our audience. Please do have a look at our website, because on there you'll see how you can join us should you wish to, and I would encourage it, because you can tell from this evening's event, just as a little taster from those of you who haven't joined us before, we have some really excellent speakers, and there's a couple more events coming up, one in November, another in December. So have a look at the events that we've got coming up, see if they suit you, and we would welcome your applications. Certainly, as we've also said, if you think of any questions but are too shy to ask tonight, then please do write in. There's plenty of contact details on that website. So thank you again to all of you, and hope you have a very nice rest of the evening. Hope to see you again soon. Bye for now.